Refuse, so we just have one Squally.
Your Honor, I have a conflict on. Thank you.
All right, good morning. We just need a moment for the Nisqually matter because the prosecutor has a conflict on this case. And so just trying to find a prosecutor to weigh in. So just please, please hold.
Understood. Thank you.
Thank you.
The record,
Okay.
but if you could handle that.
Yeah.
You have to get to the conference that everybody else is at right now.
Yep.
I'm not that my flight makes it flowers, so.
Okay. So just tell me what it is and I will catch up here.
It's, there are two matters on the 11th.
There's the SEAY say matter, which is a private counsel. The one appointed to my office is Maxine Brooks, 16D58. This came on, Miss Brooks, looks like she was sent notice of this just a couple of days ago, so I wouldn't anticipate she would be here. The file is also closed out. She successfully completed an SOC and had her DUI amended down to a negligent driving. The judgment and sentence on that was complete, except for the box marking that she was found guilty of negligent driving. You forgot to check it. And so I think everybody was on the same page. It was just sort of a Scribner's error. And so I'm not sure if we need to upload a whole new judgment sentence or if I can upload an order on motion just saying that she was found guilty. Because okay, yeah, I'm in that, I don't know why they went through with a guilty plea because it should have just been entering of the conviction, but it's works out the same way.
Okay, just let me know what date that is so I can catch up if I need to.
So I just searched by case number and but it looks like that was on 5/9 at 8:30.
What's the issue here?
She was. Files closed out. She successfully completed her SOC.
Okay.
Leg 1.
Okay.
So you can see here.
Oh, up at the top
Yeah.
where you say guilty. And this was a stipulated facts trial because of the, no?
She successfully completed an SOC and had her DUI amended to neg 1. And so there wasn't she just earned the benefit of the SOC that she completed.
Okay, well,
And
so that's, okay, that's, usually I just entered stipulated facts because basically they've stipulated for the SOC, you reduce.
sure, yes, yep. Mhm.
So,
Yep.
but I can just enter the guilty if you think that's enough, or
The stipulated facts is fine.
because if they don't go through the full call, that's just my preference.
Sure.
Everyone can do it a little differently. I've added those and then we can all re-sign if we have a comfort level there.
Perfect.
Or Judge Mansfield already signed, but I guess I can edit because
I've added my signature. I'm not sure if there's a way. I mean, our client knows that her conviction was entered and her file was closed out. So I'm not sure if we could, it doesn't change really anything for her.
And I'm gonna check the box served on defendant and order it be mailed to the defendant.
Thank you.
And you're present, so at least the record will be clear on what happened there and review the oral record today.
Great.
Anything else on that matter?
I think that is it, and I have signed that.
Okay, great.
And no objection from the city.
Great. Thank you.
And I think that's it for me. May I be excused? Thank you.
You didn't have Howard, or you said, I heard you say CA was private counsel.
Yes.
What was the issue on Howard?
Which was that?
The other correction to the record for Donovan Howard. Was that your case or no?
Howard?
Yeah, I see it on the,
Howard Donovan, correction to record.
oh, now it doesn't.
I'm not seeing it in jabs.
Or maybe,
Oh,
I see what Ms. Hickok is
maybe it
referring.
was originally calendared and then got stricken. Maybe there was an agreement.
I did not see that on the calendar at all today, so I'm not sure. It's not there anymore.
It is on there, yeah. I
Oh.
just refreshed it.
Let me take a quick
It
look.
doesn't
then.
look like your office is associated with the case, though. I don't see that or Law as a participant. Thank you.
Sounds fair enough. Okay, so we'll wait to see if Council Mattson appears on CA. And otherwise, you are free to go.
Thank you.
We're still waiting on a recommendation for Nisqually.
Have a good flight.
Mr. Gunderson, did you hear from the city on maybe somebody landing in?
Yeah, it's my understanding that Ms. Walker would be logging in.
Okay, great. The other
Correct.
refusals.
Yeah, so I think that's it. We'll address it there. And my understanding is that Ms. Walker should be logging on momentarily here.
Oh, okay. I don't know. I guess we'll look it up. I see what you're saying now.
Can I be excused for just a minute?
You may be excused for just a moment. City Representative Jeffrey Litz, 21L 000.
I'll hold. Yep.
All right, we can, we'll return to Mr. Mazier if that's okay, or Ms. Erin Mazier, whoever that is. We'll return to that matter in just a moment. Because we'll, allow the Nisqually case to take priority. And what's your client's name, counsel, please? Thank
Your
you so
Honor, this
much.
is Mr. Spears.
Good morning, Your Honor, and I apologize for the delay. I wasn't aware that I was gonna have to be popping in today, but here I am to the
Nope.
extent that I can be useful. Heidi Wachter for the city of Lakewood.
No problem. We just appreciate the appearance. So we are on Jawan Spears. This is an arraignment on 24L 0000832, one count of assault in the fourth degree. And so, sir, is your true and correct name? Can you hear me, sir?
Yes,
Okay, great. And is your true and correct name Jawan Deontay Spears?
yes,
And your date of birth, November 19th of 1993?
yes,
And you reside or receive mail at the 8907 address in Lakewood?
yes,
Okay, great. Did you have an opportunity to review with the attorney the rights that attach at your arraignment?
yes,
Did you have any question for the court about your constitutional rights?
no,
Okay, great. I'll turn it over to the public defender then. Go ahead.
Thank you, Your Honor. This is Attorney Mon on the record for Mr. Spears. We are ready to proceed with arraignment today. I've gone over the charge that is against Mr. Spears today, as well as the maximum penalty for this charge, which both Mr. Spears understands. Today, we will be stipulating to probable cause for the purposes of this hearing only and entering a plea of not guilty. Mr. Spears also qualifies for the appointment of a public defender at no cost to him, so I will also be asking for an appointment to my office.
Okay, great. I'll allow the waiver of formal reading. I'll enter a not guilty plea on one count of assault fourth degree and stipulated probable cause for purposes of setting conditions today. And I will do a direct appointment based on the record made by counsel. At this time, sir, I'm going to review your history and then I'll ask if the city wants to weigh in. What I see is an active warrant out of Puyallup, several prior charges. Let's see, several as the petitioner as far as harassment, burglary conviction, 2010. And that's about, oh, and the warrant is on the amended DUI out of Puyallup. Is the city recommending bail or release? And otherwise, I'm going to presume standard conditions for an assault fourth degree.
Yes, Your Honor, can the court hear me?
Yep,
Okay. Right now it's just a frozen picture, so I can't tell.
yep,
But,
I see that.
The city is interested in some bail for Mr. Spears due to his previous failures to appear. Record, because I am having some computer issues, as you can see, I was not able to pull up the police report, but it is assaultive behavior. And so the city is asking for 2,500 cash or bond, which should be sufficient to hold him without being unduly burdensome.
Okay, thank you. And so I'll hear from defense. I did directly appoint the public defender, so defense will represent your interests, sir. I'll hear from you, counsel.
Thank you, Your Honor. I would ask for a PR release today. I understand that there is a warrant active out of the Puyallup Municipal Court. The charges from 2018, if we look at the docket, it shows that on 4/15 of this year, Mr. Spears made a payment on that charge. There is progress happening, and also it looks like the docket indicates an adjudication of the FTA. And I otherwise also informed Mr. Spears that once he's out of custody, he can call the Puyallup Municipal Courthouse to resolve anything further that might need to be resolved on that matter, which he has no issues doing. Mr. Spears currently resides in an adult family home. The altercation happened between two individuals that both live in adult family homes, not the same adult family home. So I would ask that if the court and the city is concerned regarding the safety of the alleged victim, that we put in a no contact order. We would have no objection to a no contact order that's in place, but limiting the distance down to a couple hundred feet instead of 1,000 feet, as the parking lot is a shared space. Additionally, Mr. Spears is disabled due to a spinal injury, which is why he resides at an adult family home, and the adult family home can also bring Mr. Spears to his next court date. In light of all of this information, I would ask the court to consider releasing Mr. Spears today and allowing him to further adjudicate this matter out of custody. Thank you.
Okay. All right, so I have reviewed your history. I did see that while there was a warrant ordered back in 2020, and I think the city's request for bail is completely reasonable, I'm going to allow you a chance to appear, hoping that you're having kind of a shift in your circumstances and trying to resolve matters. And so I'm going to give you one-time chance to appear out of custody. Understand that if you fail to appear on that date, then you're going to have even higher bail than the city requested, and then you're back where you started. So I'm also going to make it a condition on top of the standard conditions to clear that warrant in Puyallup. And so I'll order you have appeared all your court dates, have no criminal law violations, update your address if it changes or has changed, use your true and legal name and date of birth, have no contact with Lindsay S. Mayor. I did grant the request. I understand the residency issue, so I made it 500 feet. It's not a formal no contact order, but it is a condition that you have no contact with that person, and I'll allow your release. Given what I previously stated, I'll set you on the July 9th calendar at 2 p.m. And that's a hearing in person out here in Lakewood. Do you know where the Lakewood Town Center is?
Yes.
Okay, so it sounds like you have some support and should be able to get to court, understand the importance of attending your court hearing. Any questions about
No.
anything further from the city or the defense?
No. Thank
Nothing
you.
further from the city, Your Honor.
Nothing from defense as well, Your Honor. If I don't know if the court officer is listening, but I forgot to get Mr. Spears' phone number. So if we can have them pop it into the chat, that would be awesome. And that'll be it.
All right, and sir, your attorney's contact information, your next court date, and your conditions of release are all listed on your court order. And so your attorney would really like to hear from you when they're released, and they're a very important piece of you having success here, okay?
Okay.
All right. Anything further? Otherwise, I'll sign that order and order that he be given a copy, and I'm checking served on defendant. And thank you so much. Thank you for the city for showing up so quickly.
Well, I'm sorry to make you wait a little bit, but thank you for accommodating us, Your Honor. Thank you.
All right, take care. All right, thank you, sir.
And if I can
Have a
just
good day.
have him ask the officer to drop his phone number into the chat. Mr. Spears, can you grab the court officer and have them type in your phone number into the chat, please?
All right, and one other question is,
Excuse
we
me?
heard there were refusals for the other two?
Yes, Your Honor. the other
On my
two-
computer out here. Okay, come here.
Okay,
Okay,
perfect.
she'll do it on her computer out there.
Sweet.
Okay.
So yes, the refusals were Ms. Bunch and Mr. Hughes.
All right, and did you have anything you wanted to weigh in on that? Otherwise, I will do probable cause findings and bail settings.
Yeah, I believe they're just not feeling well enough to show up to court today. So yes, we can find probable cause today, or we can reset to tomorrow and do it like I'm able to stipulate to probable cause as I reviewed the police reports in both matters. So if you want to call the case and do that.
Okay, that sounds good. I'll enter the stipulation. And we'll reset to tomorrow, okay?
Okay, thank you, Your Honor.
Let me tell you the.
All right, and I am going to log off.
Okay,
Thank you.
thank you. Thank you, counsel. On Bunch and Hughes, there were stipulations pursuant to the fact that counsel had read the police report. And so